Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about the mode of appointment of directors. And then we have to look at section 287 of Cama. So let's go straight to the lecture. Now, according to section 287 of the Cama, subsection 1, it tells us that at a general meeting of a company other than a private company, a motion for the appointment of two or more people, that's two or more persons as directors of the company by a single resolution shall not be made unless resolution that it shall be made has first been agreed without any vote being given against it. Now, for you to understand this section, you have to know the difference between a resolution and a motion. When you are talking about a motion is like a document that has been presented before the house. Just like when you go to court and then you want to tender a motion for the court to, give its judgment. My lord, I want to tender a motion as to this, or I want to tender a motion as to that. So in the case of a company, a person can tender a motion to be agreed upon by the members in general meeting. Now, if you want to pass a particular motion, you have to use a resolution. And I told you that to get a resolution, you have to go to section 258 of Cama. You also have to go to section 259. Section 259 of Cama deals with written resolution. Section 258 of Cama talks about simple majority when everybody is present at the members in general meeting. Do you understand? But when people are not present at the members in general meeting, for a resolution to be passed, and you want it to be a written passed resolution, then all the members must concur. That's what section 259 says. Now, coming back to what we are talking about under section 287, we have a motion, we have a resolution. This motion is telling the house that it wants to appoint more than one director. Inside the motion, Dr. Ologbenla, number 1, Dr. Yusuf, number 2, Dr. Karibi, number 3. Ologbenla, Yusuf, and Karibi, the three of them, they want to become directors, but not in individual motions before the house, but in a single motion. Now, the question is, can a resolution be passed using a single motion to make those three people directors? According to section 287, the answer is no. A resolution cannot be passed in such manner. For a resolution to be passed in the appointment of directors, then each of them must have their own motion before the house, for which the house shall vote for. Do you understand? So Dr. Ologbenla, motion A, Dr. Yusuf, motion B, Dr. Karibi, motion C. Do you understand? In the event that you want to use one motion to appoint those three directors, what you then have to do, two things. Number 1, you have to pass a resolution that such motion can be carried, because on a normal day that motion cannot be voted upon because it lacks the backing of the law. But if you want to give it the backing of the law by section 287, what you have to do is that you will pass a resolution that motion should have the backing. Then when you've now passed the resolution, which according to this section, all the members must agree. So if you have 50 members, all of them present in the general meeting, they must agree that the motion carrying those three names can be passed and they can vote on it. Then the second leg is when they now vote on it. The first leg is not the voting. The first leg is, okay, let us give it the force of law. Then the second leg is, okay, let us vote them in or out of directorship. Do you understand? Don't get it confused. The general rule is that you cannot use one motion to carry two or more directors. If you want to vote in two or more directors, use different motions. But in the event that you want to use one motion to carry two or more directors, okay, this is what you then do. You must first pass a resolution. That resolution is to authorize using one motion to carry those people. Do you understand? When you have authorized it, by which all of them must agree. If you read the latter part of section 287, it says that unless resolution that it shall be made has first been agreed to by the meeting without any vote being given against it. So you see, the first resolution you have to pass, if there are 50 members, all 50 members must agree. If 49 members out of 50 members agree, then it means that you have to split them into motion A, B, C. Now that we have known this, it means that in the event that there was no objection when one motion was to carry 3 directors or 2 directors, it means that those directors were therefore not appointed in accordance with the law, and therefore they are not de jure directors. Because if you look at section 269 subsection 1, it says the director is a person duly appointed, and section 287 already says that when you want to pass a motion, you have to do it individually for each director. Now when you go to subsection 2, it says that a motion moved in contravention of this section is void. So if you do not do it, it is void, and then those directors, even though they are acting for the company, they are not de jure but de facto directors. So whether or not it's being so moved was objected to at the time. That's just what I said earlier. Provided that subsection A, this section shall not be taken as excluding the operation of section 286 of the Act. Now let's go to section 286. It says that the act of a director, manager or secretary are valid, notwithstanding any defect that may afterwards be discovered in the appointment or qualification. I told you. So they are de facto directors, and de facto directors act are valid. So you have to read section 286 with section 276. Do you understand? Now when you go to subsection B, it tells us that where a resolution so moved is passed, no provision for automatic reappointment of retiring directors in default of another appointment applies. So with that, we already understand what section 287 is telling us. However, while discussing the mode of appointment of a director, it is also very quintessential for us to look at section 46 subsection 3. What does section 46 subsection 3 say? It tells us that where the memorandum of association or the articles of association empower any person to appoint or remove any director or other officers of the company, such power shall be enforceable by that person, notwithstanding that he is not a member or officer of the company. Can you see the language of this provision? What concerns us here is the appoint. The remove is what we'll be discussing in my next lecture. So let us talk about this appoint. Where the memorandum or articles empower any person to appoint director or other officer of the company, such power shall be enforceable. You see, when I was telling you about section 273 subsection 1, that tells us that the members at the annual general meeting may re-elect or reject directors and appoint new ones. I told you that this particular provision gives the general rule of appointment of directors to members in general meeting. However, there are certain exceptions. The first exception is what we found in section 274 that says that the board of directors can appoint directors, however, subject to 4 things: either resignation, retirement, removal, or death. Now section 46 subsection 3 gives us another kind of provision that serves as an exception to section 273, which says that where the memorandum or articles empowers a third party, empowers any person to appoint directors, such power shall be enforceable even if that person is not a member or is not an officer in that particular company. Now, does this mean that this particular appointment is subject to the members in general meeting? The answer is no. Once the appointment has been made, the appointment is valid because the memo or the articles have instructed so. And if the memo and articles instruct so, if that person exercises his power through the memo and articles, then his appointment is valid and he is de jure. The only time he becomes de facto, that's the appointed director by virtue of section 46 sub 3, is where the requirement placed in the memo or placed in the article was not carried out. Then it becomes de facto. But where it has been carried out effectively, then it becomes a de jure director. Once appointment is made, is qualified as duly appointed, there is no reason to review such appointment by either the board of directors or members in general meeting. So with this, we've interrogated the provision of section 287 sub 1 and 2. We've also interrogated the provision of section 46 sub 3. In my next lecture, we'll be talking about removal of directors. I'll see you in my next class.